Hi, I'm Robin Rosenberg. I'm the Deputy Director of Florida's Children First, and I'm so pleased to be able to introduce this video to you. I think this is probably the most important training that you can take as a lawyer for children. Let me tell you why. Florida's Children First has worked for many years to establish the right for some children in foster care to be appointed paid counsel. Their right to counsel is not just a right to have a warm body sit next to them at court. It's the right to have meaningful and effective assistance of counsel. And that means you, as a child's attorney, have an extraordinarily important job. And that job is recognized in the legislation with a promise of adequate compensation. Now, I know the statute says that there is a $1,000 limit on the fee that you can get when you represent a child each year. But that statute was passed with the knowledge of the case law that you're going to hear Nancy Wright talk about in this video. And that case law in Florida says the state of Florida cannot confiscate your time as an attorney on a court-appointed case. Your client is entitled to your full, undivided attention in doing this case, and you shouldn't have to be worrying about paying your rent or sending your children to school because you're not getting paid to do the hard work that you need to do for child clients. So when you're watching this video, I hope that you'll consider for every case that you take for a child to begin at the very beginning of that case to record all of your time, because by having contemporaneous time records, when you get along far enough in a case, you'll have the capacity to seek attorney's fees for the case that you're representing a child on. If you don't have contemporaneous time records, you're not going to be able to get the fee. And if you don't know at the beginning of the case how long it's going to take you to do a case, then in every case you should start recording your time. Nancy will explain to you how the $1,000 fee is calculated, what that $1,000 flat rate fee means. But essentially, once you work more than 27 hours, if you don't seek fees, you're giving your time to the state. Now, you get to make a judgment over 27 hours. Is it worth your time to make a fee application? But you know, many cases, you could do 27 hours in the first or second month of the case. You've got 10 more months to go. This is extraordinarily important. I know you are not doing this work because you're getting rich from doing it. You're doing it because you care about kids and because you know that your work as an attorney can change the outcome of their lives. Your work is extraordinarily important. It is valuable. We value it. You should value it. And you should take the time and effort to let the state know how much work you've done and to be compensated accordingly. And although Nancy's presentation doesn't go into in great detail the ability to get costs, those are available as well. If you need an expert witness, if you need to take a deposition, if you need to travel to see your client, and you need to travel to see your client because it's your obligation to see your clients where they live, it's your obligation to see your clients before important hearings, then that expenditure of funds will be reimbursed by the state so long as you submit the appropriate records. Your time is valuable. Your time is all you have as an attorney to make your money on, and we want to make sure you're adequately compensated. There's plenty of money in the statute. It's funded for your costs, it's funded for your fees. Don't be shy about what you're doing. Your work is valuable, and we strongly encourage you to take heed to what Nancy is going to teach you about getting fees. The case law really supports the work that you're doing. Put in your application and get compensated. Thank you for doing this work. The children are counting on you to do a great job. We know you can do a great job, and you should be compensated accordingly. So get out a piece of paper, get out your pen, take good notes, because here's Nancy Wright giving you extraordinarily important information about how you can get attorney's fees for representing children.
Hi, I'm Nancy Wright. I'm an attorney in Gainesville, Florida, and I'm going to talk to you today about how to get paid. So most of this topic is related primarily to attorneys who are doing dependency work for children with special needs, although some of it is irrelevant as to what kind of work you're doing. The first thing that we want to talk about is how do you get the flat fee, and what is the flat fee? for dependency cases. The statutory authority for that is divided between two different statutes. The first one is section 39.01305, which is the section that's very specific to dependency work for kids with special needs. And that actually, anything that's in that statute that conflicts with the second statute that I'm going to tell you about is going to overrule. The second statute is the section on private court appointed counsel, and that's 27.5304. It's important that you have a grasp of both of these sections and keep them handy because there are times when one applies over another. The other statute that you need to be aware of is the General Appropriations Act for the year that you're appointed. Those are hard to find. But fortunately, the Justice Administration Commission has a table on their website that tells you exactly what the fee schedule is based on the General Appropriations Act for any particular year. In terms of the other authority you need to be aware of, obviously, you need to understand the contract that you signed with JAC, which I know is long. But it has provisions in there that are really going to impact how much you can ask for in terms of fees over the flat rate and how you ask for your flat rate fee. And then on the JAC website are all sorts of informational material as well as their policies and practice handbook, which you probably need to have a look at as well. So currently the fee is $1,000 per child per year, and that's provided under the Chapter 39 provision. It does say that the payment is subject to appropriations and subject to review by the JAC for reasonableness. But as far as I'm aware of, that fee is pretty much indicated no matter what the circumstances. There is a provision that says you can't exceed that amount, but we'll talk about that because, in fact, you can exceed that amount, but there's a specific way they have to go about justifying that. There is conflicting language in the statute under Section 27, and it says that you only get $1,000 for the first year and not more than $200 per year afterwards. But you can ignore that because Chapter 39 prevails over this. So, when do you get paid? You get paid every year, but you can only submit your invoice for payment when you've been appointed, obviously, so you have an order of appointment. And then the submission of the invoice can only occur after the first judicial review after your order of appointment. And in the second year and thereafter, you look at the anniversary of your order of appointment, and then you can submit for the second year and third, if it goes on, after the judicial review of the anniversary, after the anniversary of your order of appointment. I know that sounds a whole lot more complex than it really is. The other option that you have is that you can wait until disposition of the case, and for a dependency case, that would be the final order of permanency. Some people might end up representing on an appeal, and the disposition would be the mandate. So you have 90 days from that date to go ahead and make your submission. If you submit later than that, there's actually a penalty. So you end up losing a certain percentage of your fee. So don't wait. How do you get paid? It's actually fairly simple, and it's an online process, and it's at the JAC website. What you do is there's an invoice and voucher cover, and it asks you for all sorts of information. You fill that out, and then you also submit your order of appointment and the first judicial review order so that they can tell that that has occurred and that you're ripe for payment. And if you're instead waiting until the disposition, then you have to submit the disposition order. Now, what can happen as a result of that is you make some mistake, you don't fill something out correctly, your order may not have in it the things that it needs to have in it, and the JAC will certainly let you know, and they'll give you, they'll send back something called an audit billing, JAC audit billing deficiency, and you can contest that if you think it's wrong, but the general best notion and less tedious is to go ahead and just fix whatever the problem might be. Once you do your invoice for a flat rate fee, you're still able to go back and get an excess fee under case law that I'm going to tell you about, and a procedure that is in the statute now. The case law are a series of Florida Supreme Court cases involving situations where an appointed counsel put in a great deal of effort and then tried to go and get a fee above the flat rate that was allowed in the statute. Many of them are criminal cases, but the cases have been also involved registry attorneys and statutory court appointment. The lead case in all of this is a case called Makemson, and it's often referred to Makemson and its progeny. So in Makemson, the court said that it's within the inherent power of the Florida trial courts to allow, in extraordinary and unusual cases, departure from the statutory fee guidelines when necessary in order to ensure that an attorney who has served the public is not compensated in an amount which is confiscatory of his or her time, energy, and talents. So there are two things here. One is the term extraordinary and unusual, and the second is the term confiscatory. Those are the two general ideas that are going to follow along in every single one of these cases. But the overarching thing is really whether or not an arrangement that caps fees to a pretty low level is going to result in ineffective representation. And that, I think, is what people need to focus on in these cases. It's really not about the attorney, it's about the client. Nonetheless, the cases, Makemson and the cases thereafter, do allow you to make claims, and you can talk about in your claims for extra compensation the time that you expended and how that impacted your own availability in terms of representing other clients, and also whether or not the case was factually complex. One of the most recent cases is a case called McLean versus Atwater. And in McLean, it pretty much repeated a lot of the same information and said that the issue isn't necessarily that the case itself is complex, but the focus is on the right to effective representation. And then, all that being said, the court will look at what was reasonable in light of your obligation to provide services to an indigent client. Were the expenses necessary? And would the cap be confiscatory of your time, energy, talent, and resources? And a little bit later on, we'll talk about the kind of things that you can put in a motion that are going to address exactly those things. So there are two cases that are very specific to the registry, and they're Olive 1 and Olive 2. They involve essentially the same fact pattern over a period of time. In the first Olive case, that was the court was asked to interpret a Registry Act requirement that the fee schedule was the exclusive means of compensation. That seems pretty, that seems like plain language. And in accepting the appointment, this registry attorney felt like signing along the dotted line in the JAC contract that also said, along with the statute, that this was the exclusive means of compensation, that he was going to waive any right he had to get extra compensation. The court held that by accepting the appointment, the registry attorney wasn't foreclosed from seeking extra compensation, and that you could go in, like Makemson said, look at the facts and circumstances of a particular case, and then compensate over the statutory cap if it would be confiscatory. Then, in response to that, the legislator went back and they amended the Registry Act, and they made the language even stronger, and they said that compensation was not authorized above the statutory cap, and anybody who tried to seek excess fees could be permanently removed from the registry. So after the court's decision in Olive 1, the legislature decided, okay, we're going to make it even more clear that we don't want anybody to get more than the statutory cap. So they amended the statute to state that the excess compensation was not authorized, and if you tried to get excess fees, that you could be permanently removed from the registry. The court was not swayed. They stood by the decision in Olive 1, and they pointed out that the decision rested on the court's authority to do things essential to the performance of their judicial functions, meaning that the court is responsible for getting effective representation from appointed counsel. They said despite that language, it's not what you think, that you can get additional fee awards, but they pointed out that to get the fee award, it requires a court order and competent substantial evidence in the record. And then they said forget about removing attorneys from the registry if they seek fees in excess of the cap. So that now has resulted in some statutory language that does at least concede that you can get fees in excess of the cap. The language in the Chapter 39 provision doesn't. It says that attorney's fees may not exceed $1,000 per child per year, but the language in the Chapter 27 provision does. It does say that the legislative intent is that flat fees comprise full and complete compensation, but then it says on rare occasions an attorney may receive a case that requires an extraordinary and unusual effort. And then it goes on to give you some information on how to show that. If you're going to seek fees in excess of the statutory cap, the Section 27, 5304, subsection 12, sets up a kind of a threshold that you're going to have to meet, and it's essentially 200% of the flat rate that you're going to need to hit in order to even ask for the extra fees. The second thing that it does, it says that even if you hit that and go above it, and going above it actually requires a separate determination that that even the 200% fee would be confiscatory. But even if if the judge makes that finding, the hourly rate can exceed $75. This is also in the JAC contract. It's set out in a number of parts of the contract that you're not going to seek more than $75 an hour. So breaking it down, that just means that in order to get excess compensation in these cases, as the flat rate now stands, that's about 27 hours in a year that you need to reach to ask the judge to compensate you for above the flat rate. So how does that pan out in terms of the case law? There's a case that's called Litem, and all of these cases are in a separate slide up at the beginning with their citations. This one is a second DCA opinion. And that actually interpreted pretty much the same provision, subsection 12, but in that case the attorney had entered into a non-standard contract with a JAC for a slightly higher hourly rate. And the court held that the attorney couldn't get more than the agreed upon hourly rate. But they did allow for an increase in the number of hours based on that hourly rate. They did leave the door open for a showing that a higher hourly rate is necessary to get qualified counsel, but it looks to me like it's going to be very difficult to overcome the fact that the agreement itself puts $75 an hour as a rate, and that the attorney signs that agreement. So, when should you file for your excess fee? The first thing to understand is that it's okay to request the flat fee and then wait for disposition to request excess compensation. It would be silly not to let you do that, because in most of these cases, I don't think you go in knowing exactly how much time and effort is going to be required. You do have to, if you get an award, then you have to, obviously you have to offset it with the flat fee rate that you've already gotten. I think you can wait until and request excess compensation at disposition. In fact, that would be my suggestion, because the process for doing this is pretty intensive, and you don't want to keep going through it. The only time that I would recommend that you go in on an interim basis to try to get compensated is if you're putting in so much time that it's actually resulting in a financial hardship for you to keep representing this client without getting some payment before disposition. So what are the steps to getting the excess fee award? The first is that you have to go ahead and prepare a motion for a fee award. This is very similar to what you'd have to do in any other case that requires a court order on a fee award. You're going to need to send the draft motion, your hourly billing invoice, which we'll talk a little bit about how you do timekeeping for that, supporting affidavits, both yours and of an expert, another attorney that is familiar with these issues, and the docket list. You send all of those to the JAC. The JAC then can respond with either a billing audit deficiency. What they're going to do is they're going to look at your hourly rate invoice, and they may come back and say, look, some of this isn't compensable, and you need to explain this, you didn't put enough detail in, you billed this, multiple things on multiple days, on several days. There are lots of reasons that it could be deficient. So you have an opportunity to correct that, which is a great idea, because a lot of the things that are deficient would also make the court a little irritable. If there is no deficiency, then they'll send a letter of objection or no objection to your fee award. That doesn't mean you get it. That just means that that's nice to have, because when you file the motion with the chief judge or the chief judge designate, you're going to have to attach that to the that letter to your motion. The statute's pretty specific that this either has to be handled by the chief judge of the circuit or a single designate for all of these cases. So talk to your clerk, see who's doing that. Suggestions to include in the motion. Obviously, you're going to put in the history of the case. You're going to want to talk about your own experience. It's been suggested that you put in what your overhead per hour is. I don't think that that's necessary in all circuits, but apparently some judges believe that that's an important piece of the puzzle. Then you want to give a pretty thorough explanation to support the circumstances that required extraordinary and unusual efforts. Some examples of that are any special expertise, areas of law that you had to go into that were unusual. How taking this case impacted your ability to take other clients. That's a pretty important piece because it's mentioned in the Supreme Court cases multiple times. Any unusual travel requirement. Talk about the stakes involved. I mean, if this is a situation where what you did or what you were trying to do was to keep a child out of an institution, that's a pretty big stake. And then talk about the results of your efforts. The next thing that you'll have to do is, if you're trying to get more than 200% of the flat rate, is you're going to have to give an explanation as to why that would be confiscatory. Some of that will be handled by some of the other information that you've given to establish the extraordinary and unusual efforts. But this is primarily related to the financial impact on you. You need to attach to the motion your JAC letter of objection or no objection, your own affidavit verifying your billing and expenses with the hourly invoice attached, and an expert affidavit on the reasonableness of the hours and the impact of the time spent on private practice from taking that case. So that is always done by another attorney. It's preferable if you get an attorney in the area, but you don't have to. And it's really a good idea to get an attorney who's very familiar with the types of issues that you were dealing with to make that decision and on your behalf. So next, we're going to talk about why bother keeping time if you're mostly going to end up just taking a flat rate. There are probably a lot of reasons to keep time, but here are 4 good ones. The time records could support a legislative increase for the statutory fee rate. That's not something that's going to happen in your individual case, but I think it's important that the JAC and those people who advocate for children collect that information and have the legislature make a better decision perhaps on what appropriate fees would be. If you need to withdraw, you can defeat the presumption against your claiming the entire flat fee. So if you've put in 20, 30 hours on a case and then you have to withdraw for reasons that that might deal with your health, or that there's something that you couldn't prevent, I think the time you've put in could justify the claiming the entire flat fee. It provides evidence of your efforts if your client challenges the adequacy of your representation. And the number one reason is that if you fail to keep contemporaneous time, you waive the right to seek compensation in excess of the flat rate. That's in both the contract and the statutory provision in Chapter 27. I've had a number of these cases, and I've been called in to represent and been assured that this is going to be easy and quick and that the child's going to be adopted in 2 months, and I'm out of the case. And then, as we all know, things happen and things blow up, and now I'm 30, 40 hours in. Had I not started taking time during that initial period when I was assured it was all going to be easy and quick, I would be completely prevented from asking for those excess fees. So you never know. There are some ethical reasons to look at your timekeeping as just part of your professional obligation. And I think it's mostly dealing with your ability to be effective in your representation under the rules of professional ethics. 4-1.8, subsection 5, that's compensation by a third party, which is what is happening with you. You're being compensated by a third party. So you have to meet the requirements of that section, and that requires that there's no interference with your independent professional judgment. Well, if you're going to take a case on a flat fee and you really think that it's going to limit your ability to effectively represent a client, you shouldn't take it. And keeping your time so that you can get that extra fee if need be is, I think, part of your obligation to justify that you still have independent judgment. Under the rule about accepting appointments, 4-6.2, that rule says you shouldn't avoid appointments, court appointments, except for good cause, such as when representation could result in an ethics violation or when it would result in an unreasonable financial burden. And I think both of those provisions really kind of charge you to make sure that your time is kept. So how do you keep good time? It has to be contemporaneous. That doesn't mean instantaneous, but it certainly means within the day. It has to be a single subject entry on a single day. So it is possible to kind of group on a single day as long as you keep the actual time you spent on a particular aspect separate. I think the better way to go is just to keep time in terms of single subject entries. You definitely cannot go over into a different day. You do it at 1/10 hour intervals, which requires that you be able to multiply and divide by 6. And you have to give sufficient detail so that whoever's reading these invoices and the hourly rate understands the topic and the effort. That means you need to, instead of just saying deposition and then the time, who did you depose? Who did you interview? Who did you call? I mean, I think the vast majority of my time is phone calls. And not only do I have to say who I called, but what was the topic of that call. If you are going to draft a pleading, you need to name the pleading or the motion or the discovery that you work on and be specific about the aspect of the discovery. If you're going to review documents, orders, motions, anything that you read, include the number of pages. The JAC in some of their materials has a presumption of 2 minutes per page, including taking notes. You can support a longer time than that, but I certainly would put it in the time category. You have to identify the legal issue researched and the types of cases. I don't think you actually have to list the cases. Many of us blow through cases like crazy. That would be a hard thing to have to include in your time. But if you're looking at really long, intense cases, I might include those and then put the number of pages. A really good practice is to put things in that are no charge to show that you have decent billing judgment. And I'll explain a little bit about what some of those things might be. So bad time is block billing, which is a single entry over several days. Like preparation for trial, that's a typical example. You know, it runs over 3 or 4 days. And that's also the same with lumping. Even if it's in a single day, you really have to tease out what your trial preparation required of you. Giving insufficient detail, putting an unreasonable amount of time for any entry. For instance, when I do phone calls and I realize that part of that phone call involved some just chit-chatty stuff, I drop it down. But sometimes I'll do that and put it as a no charge. The time divided among clients or tasks exceeding the actual time spent, that's actually an ethical violation as well. And then if you use abbreviations that your reader is not going to be able to understand. Very bad time. This is actually time that the JAC will not ever authorize for reimbursement. Services by support staff and clerical services that are done by an attorney. This is where detailing your time makes a big difference, because you could just say that you've worked on some meeting arrangement and that looks like a clerical task, but then if what you've really done is negotiations as part of that conversation, that's compensable. The time relating to billing or getting fees, which is a kicker. I mean, it takes a while to get excess fees. It's going to take some effort. That's why I suggest doing it once. The time reviewing expense invoices, you can't get paid for that. Time not reasonably related to the merits, which looks like it's kind of routine, mundane things, much of which is typical of a support staff, like routine notices and setting up meetings. You can't bill for time defending a bar complaint or grievance, or for time communicating with the JAC. The process itself looks like it will be fairly time consuming, and it probably is if you've never done it before, but I still recommend that you make a stab at it if you're putting in a lot of hours on a case, because your time is worth something. I think once you've done one of these sorts of motion hearings in front of a judge, it definitely becomes a little easier the next time and doesn't take as much effort. And at that point, you've probably got an expert attorney that you can contact, and you got your templates. So keep your time and get your fees. Thank you.